From the supplementary list, at 215 under heading for orders targeted case item 1, CWJC 2877 of 1999.
But I'm grateful for not giving me longer agenda. I was supposed to read and finish only.
Proceeding is arising out of mutation orders and has nothing to do with this.
No, yes. Basically, this is leadership members have already seen. It's all the impact of Annexure 9 and validation. That is the only question. I succeed in that, I succeed, otherwise I just assisted. I'm sorry that I could not prepare a fair list of dates for being passed on to the court. But I will just point out here.
No, even this Validation Act will have no bearing in this case.
Is it?
The reason being that there was two parallel things. One was the suit, another was the mutation proceedings. Suit was instituted in 1966. Thereafter, the matter was sent for arbitration. Award was passed, and thereafter the authority decreed the suit. Then the matter went in appeal. The appellate court said that he does not have the jurisdiction, pecuniary jurisdiction or whatever.
That's
And that
on the date of deciding he had, but on the date of admission he did not have.
we do not know, but that
That's
is the
what
order. That is
That's
the
what is
order.
the order.
Yes, that is the order.
That he has been conferred with the authority only after the date of admission.
That's
That's the order.
So, anyways, that order became final. Then the plaintiff went back, got the plaint returned, refiled it in another suit. Another suit was also instituted in 73. And subsequently, the suit was not taken to a logical end. It was not instituted. And that applicant did not take any steps thereafter. In the meantime, there has been a numerous mutation proceedings.
So eventually, commissioner dismissed that appeal which was pending before him.
Yes.
His second suit was not taken to logical end on the premise that commissioner has granted a stay,
Okay.
and then commissioner dismisses. So my client ought to have done something.
Ought
Did
to have
not
done something.
Did not.
He can still do it. It's a property dispute. What's the big deal about it?
But even with respect to this matter, I'm confining to this. Even with this, I mean, my respect to submission, the case survives. Because after this development,
Which case survives? 73 suit.
yes.
That is not the subject matter of consideration. If it survives, it survives.
No, the original suit, the appeal was dismissed. The appeal was dismissed by the commissioner, and we did not do any refile. The appeal was dismissed by the commissioner, and that's important.
No, you see, just let's take the dates. Let's take the dates. First is title suit number 66, 28 of 66, 1966.
Yes.
Award is dated
Award is dated 24 January 1970.
24/1/1970.
But before that, there is one important date. That date is Koran Civil Justice Regulation and Balloting Act 1966 coming into force on 20th of March 1967.
Annexure 9 coming
Page-
into
page
force
71.
on? Yes, coming into force on
20th of March 67.
23/67. Correct? Then award was
And
passed.
then award comes. Now what happens is the
No, let's finish the date. You have
Yes,
not prepared
yes,
the
yes,
dates.
Yes, yes.
Then
And
this
decree is
suit
drawn
was
on-
decreed.
Your Lordship, the decree is drawn on 26/5/71.
26/5/71.
That's Annexure 4, page 47.
Annexure
4, page
4.
47.
Okay. Appeal filed against this.
Appeal file against it, and the order comes on.
Appeal case number.
Pardon?
Case number.
Yes. KTS.
KTS, KTA.
KTA
Hmm.
Commissioner in appeal sets aside.
It is a title appeal 107,
It's
71.
page 59.
107 of 71.
107 of 1971.
Okay, decided on
Thank you.
Decided on.
Decided on 20th of February 1973.
22 1973.
That's annexure 5, page 59.
Annexure 5, 59. Appeal allowed.
Appeal allowed. Set aside annexure 4.
Okay.
The ground was that the additional commissioner was empowered by the deputy commissioner with respect to suits exceeding value of rupees 300 only on 28th of December 1968.
It means that on the day the suit was filed,
The suit was admitted on 1967. So he has said about the date of admission.
1967.
19
So-
June 67, he had no power.
He had no power. The day that suit was filed, he had no power.
Yes, the same day suit was
Admitted.
filed was not, he was not having no power, admission no power, but the day he decides,
Yes.
he's in power.
Right. Okay.
I would have perhaps argued it in a different way.
Yes. This order became final.
This order became final because,
Plaint was returned.
yes.
Plaint was returned.
24th of, then that's why I said there ought to have been refiling on this return.
Just
Now,
just a return to plaintiff. She filed a suit. A suit was filed thereafter.
in addition to that, the award is the degree of progress, and then 21st of July 1973, the additional commissioner allowed return of claim
21.
in the same suit.
So 21,
21 July 1973.
773. Plaint returned.
The original trial court, additional, whenever I am saying additional trial court, I am meaning additional deputy commissioner. He allowed the return of plate. This order was passed in the same suit.
That's
It-
right.
it is
Naturally.
28.
Naturally.
This is annexure 6, page 61.
That's right.
Annexure 6, A6, P61. Then, the other side,
No.
filed
no,
an
no.
appeal.
No. Against this return of plaint.
Yes,
Against this return of plaint.
he filed a suit in 1973.
No.
Yes.
This
19,
after return of plaint, she filed a suit.
no, not she.
No. She.
Yes, she files a suit, but before that, this happens. Just before that, in addition, is right. That's the next day. Before that, since I'm giving date, in 1973, first he filed a suit against plain return.
Suit against plaint return.
Yes, that's Ulhan
But-
title appeal number 96 of 1973. In addition, he filed
Ulhan title appeal
a-
number
96 of 1973.
96 of 1973.
Was filed by
This was filed against order dated 21/7/73.
Yes. This was filed by the private respondents hearing. That means respondent number 4 and 5.
Order
Who were the
dated
defendants in the suit?
21/7/73.
In addition, we just mark the defendants rival against me in the suit are respondent number 4 and 5. So I will be referring to them as contesting this one. So they applied against plaint return, and I, acting on the order of plaint return, refiled it on return as Ulhan title suit number 34 of 73 before the same additional deputy commissioner, because now he is empowered.
Ulhan title suit number
34 or 73.
34 or 73.
Now the gentleman, additional deputy commissioner, admits this ATS 34
Admitted
on 4th of December 73.
4/12/73.
Yes.
Then
But then on 12/11/75,
12/11/75.
he passes an order which I have challenged.
Annexure.
Annexure 7, page 65.
Annexure 7. Saying what? What
Saying
does it
that since the first suit was stayed, first suit 28, suit
It
number
was not
28,
state.
he has said so.
Said so means what? Show me.
He has said so in the order.
State means what?
The suit,
The
appeal-
suit was already dismissed. The appeal was already allowed.
The return of plate was allowed. Return of plate was challenged by them in appeal. In that appeal, the appellate court had granted a stay, which is the
Stay of the fresh suit.
So yes, he says that there was a stay against plain return order. There was a stay in Appeal 96.
Okay.
Therefore, admission of second suit is impermissible. That's what is Annexure 7. He says in sum and substance, since the first suit number 28 was stayed in Appeal number 96, therefore no admission of the second
You
suit.
see, the suit was not
No,
stayed.
no admission of
The
second suit
return of the
was
claim was
permissible.
stayed. Return of the claim was stayed.
Therefore, if the plain return is stayed, then there is no question of this plain being
Utilized.
Utilized.
That's
He said that the second suit's registration as 34 was impermissible. That's what he says.
return.
In this
the
way-
suit was not surviving by any means. The point was whether the plane was to be returned or not to be returned.
Plain, upon return of plain, what will happen? Natural thing is that upon return of plain, a fresh suit will be filed.
Yes,
Get
but,
registered.
but-
I would say, it
but
will be
if
presented.
it can be represented. A fresh suit can otherwise also be filed,
That's a different thing.
right?
That's a different.
So the same plane will be represented and a fresh suit will be instituted.
Whatever.
The original suit will not revive by
Right.
any means.
Right.
Right? Maybe that it is
Number would be
represented.
different.
Maybe it is represented before the same authority.
Maybe.
But original suit will not revive. Right?
So there was a refiling required. The
Yes.
refiling was impeded by this.
Yes.
So that's important in addition to taking. Refiling was impeded by this Annexure 7.
Yes.
Annexure 7 said that admission of second suit is impermissible.
Okay.
And
This was passed in.
as luck would have it, this was passed in Annexure 7, page 65.
Yes.
This was passed in the second suit, suit number 34.
Yes.
Suit number 34, he says that although I have entertained it, but since there was a stay, this admission done by me in past was impermissible.
That's right.
So now I have.
Now this
I am
suit also
remitting
does not
this-
survive. No, this suit also does not survive.
Right. Therefore, this order has to be set aside. If your leadership is pleased to set aside, then what happens? Then we go back. Because this is going to come in my way.
What happened in title appeal
Yes.
number 96 or
Title
73?
Appeal 96 was also dismissed.
When?
4th of December 1979. Annexure 8.
4/12/1979.
Annexure 8.
It was dismissed.
Yes. Page 68. And that completes the story. So far as what we were doing against each other.
If annexure 8 is dismissed, then the natural corollary would be that annexure 7 would go.
Yes.
Right?
Should go. Should
Just a moment. Natural corollary is that annexure 7 should go. And once this annexure 7 goes, the title suit revives. And what revives is title suit number 34 or 73, which was already admitted on 4/12/1970.
But technically, Annexure 8 did not set aside Annexure 7. It should have been the consequence.
It is just a consequential. Annexure 7, annexure 8 will not set aside annexure 7.
So this is the position we are faced with.
You see, the title suit number 34 or 73 was already admitted. The order of admission revives and title suit has to be decided on its own as per law.
That has to be ordered.
इतना हो जाए.
बिल्कुल. उसके बाद Annexure 12 जो है वो क्या है? Commissioner then
And एक second, annexure 7
then,
जो
then,
है,
then what happened? The second round. This is one part. Incidentally, this is all my first page. Then secondly, what happens is, in fact, whatever she was observed and found out, that is the crux of the matter. If up to Annexure 8, the leadership is able to come to this conclusion which I am contending on the basis of Annexure 9 validation, then all everything else will
it should
fall in
not be on
place.
the basis of annexure 9. I don't have to say anything on that.
So may I place Annexure 9?
Then under such circumstances, if that is dismissed, then this title suit will revive.
Yes.
And whatever be the point,
Exactly.
jurisdictional point,
Exactly.
whatever it's
So technically, leadership Annexure 12 has to be set aside. On mutation, the issues have to be left.
No, I will not say that. I will say that these are all orders of mutation.
I leave it upon your
Mutation, you see, mutation will not decide the title. It is a title suit.
Exactly. I'm saying that I am leaving it upon the higher wisdom of the court. I'm just pointing out the facts. Just give me 2 more minutes. Just 2 more minutes. After this commissioner dismissing the appeal number 96, you may imagine what would be the condition of the respective parties. So what my client does is, my client, the petitioner and the pro forma respondents, of course, they filed a mutation application afresh before C, on the premise that the earlier mutation was under challenge and then the degree was decided in my favor, award was passed in suit number 20 and all that, stating all those things. So that mutation case was registered sometimes in 1989. So the number is mutation case number 17 of 1989-90. This mutation was registered. CO dismisses it without hearing on 18/12/1990. LRDC dismissed the mutation appeal on 14/10/93. That's mutation appeal number 5 of 1991. And then an order comes in my favor.
14th April
14/10/93.
93.
And then on 27/9/95, Annexure 10 is passed by divisional court in my favor. Annexure 10, page 75. So this divisional court is additional deputy commissioner who allowed mutation revision and ordered for mutation. That's Annexure 10 at page 75.
Yes.
Then my case is then mutation was done, rent was paid, rent receipt was issued. So rent receipt is before my law, before relationship at Annexure 11, page 79. Then there was a second revision preferred by them which was allowed, which is also under challenge. That's the completeness of the story. The second revision, you will just take note of the date. Second revision was allowed by the commissioner on 20th April 1999. And the ground is very strange. In addition, the ground taken by him to allow the revision is that there was lack of pecuniary jurisdiction with the additional deputy commissioner while decreeing the first suit. That's incorrect. And second, whether this commissioner had the power of second division in 1990.
His power was deleted.
1983 or 1983. So, mutation
61 वाला जो act है, mutation laws by 70.
Could I see the book which by this possible? Section 7. But this is all incidental validation. The fact of the matter is that the suit should decide everything.
This
So none of
revisional
us-
power is given to whom?
Divisional power is given to the collector. Section 16.
Collector includes additional collector.
but then one more validation act has come in. Yes, collector includes an additional duty commission. Definition clause C. Is only with regard to any other officer other than additional duty commissioner that a specific empowerment is required.
Therefore, your revisional order in your favor was passed by the additional collector. That was also without jurisdiction.
No, he was as good as collector as per the definition of clause C. He was the appellate, he was the revisional authority. Clause C, definition clause C read with section 16.
All these judgments are there that the revisional power of revision cannot be exercised by the additional collector. It's only the collector of the district. And these points.
Collector includes an additional duty commissioner.
ये लाइए तो 2009 वॉल्यूम 3 एसएससी 2009 वॉल्यूम 3 पीएलजे 974
And one more thing, that validating act was followed by another validating act. I'm just pointing out, which is at page 73. With the same effect.
I don't want to pronounce upon this validating act. Why should we? Now that order by which that appellate order has already been set aside in appeal.
In addition, we consider giving up Vitus. In addition, decides to pronounce.
Yes.
Otherwise, we go back.
You go back and get your title suit decided.
It is the
But on face of video ladyship, by reading these documents plainly, it is patent that the jurisdiction was there by virtue of this validating act.
You see, once the return of the plaint
Has led to another suit.
and has led to
And
another suit.
followed by it, that suit's revival. Ladyship wants that it should be taken to logical end instead of
Yes.
any pronouncement coming from this
Why
suit.
should
That
we
normal
pronounce?
thing we
Because
always-
everything will be left open. Whatever be the jurisdiction or we do not know 73 का सूट कुछ बोलने के लिए नहीं रहेगा.
I am trying to pay review to the draftsman of this application, who was an expert in this subject. Going through these drafts is an emotional journey, in fact. तो अपना बोलने की सोचिए हमको कितना समय लगता है और ये सब पता है
तो रेफरेंस केस भी चल रहा. LA reference case is also pending.
Must be.
88 का.
Must be. I don't know. We are not in touch with the clients.
ये डिविजनल ऑर्डर का क्या करें जो इलेक्शन 12.
Should go. It's an order without jurisdiction. It should.
Then the order of the collector deputy, this is also without jurisdiction.
Maybe, yes, that's the law.
No, the other
If
one.
That's the law. Yes, I'm talking against myself. That's the law. Legal position is that if the writ court is faced with a legal order and it has to set it aside, which would revive another illegality, then it must either refrain from exercising powers or must exercise powers to set aside both. There is the judgment.
So
Shall I
therefore both has to-
give that judgment? Shapur Basti Samsthan.
Sorry.
Shapur Basti Samsthan. That's the judge. Shamshan. That's the judgment. I can take it. Shapur is Sapur Shah. S-A-K double O. Paragraph 14.
So therefore, it should be suffice that everything will depend upon the adjudication in the suit, whatever be the position.
Judiciary may observe that both these orders are illegal without jurisdiction. Eventually, what order should be passed should depend upon the outcome of the suit, which is pending. That's it.
And reference case is also pending. So ultimately, the title of the parties will be decided in the suit,
Yes.
which will have a bearing on the reference case, isn't it?
Yes. Therefore, I am saying that instead of taking any risk of entering into something which we don't know about, because passage of time and availability of parties.
And otherwise also the
Yes.
division court has said that it will depend upon the judgment to be passed by the appellate court. So we can simply say that it will depend upon the
Therefore, I am
judgment to
saying
be
that
passed.
the regime only declare the legal position
Yes.
and leave it upon the trial court to decide.
तो जजमेंट आया क्या?
मांगनी चाहिए
लेकर आइए.
जी
That should be sufficient. CWJC number 2877 of 1999 within that.
I was just putting a question to myself. Whether exercise of power by the additional collector will also be saved by this validating act. Whether he was doing that in Burhan area.
This was all going through the under the mutation laws. This was all under mutation laws.
Just-
All these orders are under mutation laws. It's not that mutation laws will not be applicable. The
No, it may be applicable, but just let me place the language of that validation. Just once. Page addition 9, page 71. Notwithstanding anything, page 71 validation.
yes.
Clause 2.
Hmm.
Notwithstanding anything contained in any other law for the time being in force, or any judgment, decree, or order of any court, the officers mentioned in column 1 of the schedule shall, which means additional duty commissioners, shall, in regard to the trial of civil suit and proceeding arising within the local limits of Burhan, proceeding arising within the local limits of Burhan, with the exception of the areas comprised within the municipality of Chavasa, we are not concerned with this, and hearing of appeal. So, in addition, civil suit as well as proceeding is covered by this. And hearing of appeal, review, or revision arising therefrom, exercise the powers which the officers mentioned in the corresponding entries in column 2 thereof, exercised under the Wilkinson's rule. And 17 always
It is relatable to Wilkinson's rule. This is not relating to mutation.
It just flashed in my mind, sorry.
It is all basically the legislature, whatsoever the wisdom may be at that point of time, they have given a forum for suit. Like suits are decided under Chota Nagpur Tenancy Act, it is being decided by the revenue officer and validly decided. There is no doubt on that. Similarly, these authorities have also been given some right. Case CWJC number 2877 of 1999 within bracket R. This petition has been filed for the following reliefs. During the course of hearing, it transpired that terms of reference का है full bench में. During the course of hearing, it transpired that an issue arose as to whether Wilkinson's rule is not a rule framed under section Roman 5 of Regulation 13 of 1833, nor can it be said to be a statutory rule having binding force. Para 12 of the judgment.
Actually, para 11 is that also.
And the matter was referred to full bench. On the ground that the judgment passed by division bench reported in AIR 1958 Patna 366 and AIR 1958 Patna 603 required reconsideration. Paragraph, the full bench judgment has been rendered by judgment dated 5th of January 2000, reported in 2000 SSC Online Patna file in CWJC number 198 of 1979 within bracket R. Para 10, 11 and 12 जो है ना ये ले लेंगे इस जजमेंट से 10, 11 by a majority judgment the Honorable Full Bench all the three judges the two of the judges have taken conflicting opinion, and one of the judges concurred with the finding of one of the two. The court held that the Wilkinson's rule shall continue to be followed in the administration of civil justice of Pulhan till suitable rules/regulations are in place, and those rules have been framed by the government. The state government was directed to do the needful within a period of 3 months from the date of receipt of the copy of the judgment. In the present case, the orders passed in suit filed under Wilkinson's rule are under challenge, and certain orders passed in mutation proceedings are also under challenge. The learned counsel for the appellant has submitted that one title suit number 28 of 1966 was instituted by the plaintiffs of the present case.
Yes.
By the plaintiffs of the present case. By the ancestor of the plaintiffs of the present case, which was sent for arbitration, and an award dated 27/1/1970 was placed, and ultimately the title suit was decreed by judgment dated 23/1967 against the judgment entitled
23/1967 is the date of the Pulhan Civil Justice Deliberating.
okay sorry
The award had come on 24th of January 1970.
24th of January 1970, and the suit was decreed on 26/5/1971 within bracket annexure 4 against the judgment in the title suit. Appeal was filed numbered as Pulhan Title Appeal number 107 of 1971, which was allowed by judgment dated 20/2/1973 within bracket annexure 5 on the ground that the day on which the title suit was admitted by the authority did not have the pecuniary jurisdiction. this order attained finality. Did not have the pecuniary jurisdiction. This order attained finality, and ultimately the plaintiff applied for return of plaint. The plaint was directed to be returned by the order dated 21/7/1973. Within bracket, Annexure 6. Upon return of the plaint, another suit was filed, numbered as Kolhan title suit number. Number Kolhan title suit number 34 of 1973, which was admitted on 4/12/1973. In the meantime, the order returning the plaint dated 21/7/1973 was challenged in Kolhan title appeal number 96 of 1973, which remained pending, and the Kolhan title suit number 34 of 1973 was dismissed on 4/12/1979 within bracket Annexure 8 on the ground that
First thing, in addition, the report that the challenge was preferred by respondent of 4 and 5 defendants.
yes,
Then,
whosoever is challenging, how does that?
12/11/1975 is the date of the order of additional commissioner. That's Annexure 7, page 65.
Yes,
Which he said that since suit was stayed in appeal, no admission of second suit was passed.
yes,
Date is 4/12.
yes.
Commissioner's dismissal.
However, since the Kolhan title appeal number 96 of 1973 was pending and the suit was stayed, therefore the subsequent suit numbered as Kolhan title suit number 34 of 1973 was dismissed on 4/12/1979 Annexure 8. However, ultimately, the Kolhan title appeal number 96 of 1973 was also dismissed
On 4/12/79.
on 4/12/1979.
The language used was suit is struck off. So this is here. The suit is therefore struck off.
And the suit was struck off.
Right? This is the very
ये वाला जो है ना 12/11/75 में लिखिएगा, the suit was struck off. The Learned Counsel has fairly submitted that once the Kolhan title appeal number 96 of 1973 filed against return of the plaint was dismissed, then the Kolhan title suit number 34 of 1973, which was instituted after return of the plaint, ought to have been taken to a logical end.
There is one thing I must point out. The suit struck off. The civil sentence is worth being placed. There was thus no scope for this court, additional commissioner is saying, additional collector is saying. There was no scope for this court to admit the present suit on 4/12/75. On this score also the present suit is not maintainable in law when the original suit is still pending in appeal.
That's right.
Original suit rely करेगा कि ये वाला करेगा.
The Learned Counsel submits that once the Kolahan title appeal number 96 of 73 was dismissed. The Kolahan title suit number 34 of 1973 would revive, which is required to be taken to a logical end. He submits that in the meantime, certain proceedings were also initiated for mutation. And the order of mutation was passed in mutation case number one.
The second one. This is mutation case number 17 of 1989-90.
Mutation case number 17 of 1989-90.
Which you will find all these pleadings at page 29, paragraph 26. All culminates into that order of election.
Yes. The application for mutation was dismissed. Ultimately, an appeal was filed before the Land Reform Deputy Collector, Chaibasa, which was registered as mutation appeal number 5 of 1990-91. The appeal was also dismissed on 14/10/1993. And against the order of dismissal of appeal, one mutation revision was filed before Additional Deputy Commissioner Singhbum West, Chaibasa, numbered as mutation revision number 18 of 1993, who allowed the revision by the order dated 27/9/1995 and the order of the circle officer dated 18/12/1990 and the order of land reform deputy collector dated 14/10/1993 were set aside, and the Antal Adhikari Chaibasa was directed to mutate the land on the basis of possession on the ground of nearest agnates of Chiriki Queen in favor of the petitioners and the pro forma respondents. The said order was challenged.
In the meanwhile, rent receipt was
In the meantime, rent receipts were issued and the order passed by the additional collector was challenged before the
commissioned.
additional deputy commissioner. The order passed by the additional deputy commissioner was challenged before the commissioner. In mutation revision number 476 of 1995. The state authority by direction 12 dated 20/4/1999 recorded that a land reference case arising out of acquisition of land was pending, which was decided in land reference case number 16 with the bracket 14 of 1988, which was challenged in appeal and the same was pending. And also observe that the parties would be governed by the judgment to be passed by the appellate court. And ultimately, the order passed by the learned Additional Deputy Commissioner West Singhbhum was set aside. यही हुआ? The Learned Council has submitted that the right, title and interest the Learned Council submits that once the title suit, which has now, once the title suit number 34 of 1973 is taken to a logical end, all the dispute between the contesting parties will also stand decided, and therefore it would be suffice if it is observed that Bolhan title suit number 34 of 1973 be decided as per नाम से हो जाए.
And the commissioner's order will be satisfied. So, these orders have to be satisfied.
The Learned Council has submitted that the order of the Commissioner dated 24/1999 be set aside. We have submitted that the second revision is not maintainable under the provisions of Bihar Tenants Holding Maintenance of Records Act 1973.
Technically, your petition also considers setting aside Section 5 and 7. The Commissioner's dismissal of Appeal 96 has not said anything about Section 7. I think you should go back to the
If we revive the suit, that will be sufficient. The Learned Counsel for the private respondent has submitted that if the title suit number 34 of 1973 stands revived and is decided as per law, he has no objection. So far as setting aside the order passed by the Commissioner is concerned, he submits that though the second revision was not maintainable, but at the same time the Commissioner has set aside the order passed by Additional Deputy Commissioner in exercising divisional jurisdiction. Even the Additional Deputy Commissioner did not have the jurisdiction to entertain the revision. He submits that since the order of the Additional Deputy Commissioner would revive, which itself is an order without jurisdiction, therefore, the order setting aside the order dated 24/1999 be not set aside. यही बोलना आपको?
Judgment citation 2007 volume 13 SCC
2007 volume 13 SCC
page 53
page 53
paragraph 43.
paragraph.
It's one sentence where I just read it. It is now well known that a writ court in exercise of its jurisdiction under Article 246 of the Constitution of India need not quash an order if it gives rise to another legal order, or may quash both the orders.
इनकी तरफ से लिखा, the learned counsel has relied upon the judgment.
ऑफिसर ऑफ द कोर्ट है सब दे रहे हैं अपने से.
अपने से इतना तो ड्यूटी आपको बनता है ना.
तो बनता है कुछ तो हमको भी.
ये आपकी तरफ से आना चाहिए. हम लोग दोनों का हो गया, फिर आपकी तरफ से आएगा द सॉल्यूशन.
The learned counsel has relied upon the judgment passed by this court reported in 2009 with the bracket 3 bracket close PLGI 975 to submit that Bihar Tenants Holding within bracket Maintenance of Records bracket close Act of 1973 confers revisional power only upon the collector of the district and has submitted that the power of revision exercised by the deputy, by the additional Deputy Commissioner West Singhum in mutation revision number 18 of 1993 was itself without jurisdiction. After hearing the learned counsel for the parties, this court finds that the sequence of events as narrated by the learned counsel for the petitioner. आपको कुछ बोलना है?
The second title should be decided on
The learned counsel for the state has submitted that with the second title suit, that is title suit number 34 of 73 is decided as per law. The dispute between the petitioner and the private respondents will automatically come to an end. Yay?
State will support with its infrastructure.
The learned counsel for the state has submitted that since the title suit is of year 1973, some observation may be made for its expeditious disposal. And the state is ready to cooperate for expeditious disposal of the title suit. इतना तो बनता ही है. आप लोग सब आपके जन्म के भी पहले का है और इनके जन्म के भी पहले का है ये सब सूट.
लेकिन मेरे जन्म के बाद
आपके जन्म
तो इंसेंस रोल के पहले के हैं, तो बात कर रहे हैं.
66 का भी है एक. After hearing the learned counsel for the parties, this court finds that the sequence of events as narrated by the learned counsel for the petitioner is not in dispute. This court is of the view that the title suit number 28 of 1960, which was decreed on 26/5/1971, was subject matter of appeal in KTA number 107 of 1971, and the appeal was allowed, and the decree was set aside and the appeal was allowed by judgment dated 20/2/1973 on the ground that the suit itself was wrongly entertained for want of pecuniary jurisdiction on the date of institution/admission of the suit. The order of the appellate authority became final, and ultimately the plaint was returned to the plaintiff on 21/7/1973. It appears that thereafter the plaint was refiled and was instituted as title suit number 34 of 1973 and was admitted on 4/12/1973. In the meantime, the order dated 21/7/73 by which the plaint was returned was challenged in KTA number 96 of 1973, and admittedly the title suit number 34 of 73 was instituted during the pendency of the KTA number 96 of 1973. When this fact came to light of the authority, the subsequent suit, that is title suit number 34 of 1973, was itself decided by holding the suit be struck off. The order of the appellate court in KT suit number 34 of 1973, the operative portion is quoted as under. However, the reason for which the order reveals that the suit was struck off primarily on account of pendency of appeal KTA number 96 of 1973. After the passing of order dated 12/11/1975 in KT suit number 34 of 1973, striking of the suit itself, KTA number 96 of 1973 was dismissed, while judgment dated 4th of December 1979 within bracket annexure 8 with an observation that the principles of natural justice demand that the suit be heard. ये देखिए क्या लिखा है, पेज नंबर 3. Page 70. And ultimately the appeal was dismissed. है ना?
Yes.
This court is of the considered view that once Kolhan miscellaneous appeal है. Miscellaneous appeal number 96 of 1973 was dismissed, challenging the order regarding return of plaint. The suit which was filed upon refiling automatically revived, which was title suit number 34 of 1973. The order dismissing title suit number 34 of 1973 reveals that the same was dismissed primarily on the ground of pendency of title appeal number 96 of 1973. Once the title appeal number 96 of 1973 was itself dismissed, and by dismissing the appeal, the court observed that the principles of natural justice demands that the suit be heard. Therefore, there can be no doubt that title suit number 34 of 1973 revived. Even the learned counsel for the parties during the course of arguments do not dispute this position based on the materials placed on record. Accordingly, on account of subsequent development, the order striking off the suit passed in KT suit number 34 of 1973 does not survive anymore. And it is sufficient to observe that KT suit number 34 of 1973 is revived. So far as the judgments, the orders passed in mutation proceedings are concerned, there can be no doubt that second revision was not maintainable. But at the same time, the order which was subject matter of second revision was itself passed by an authority who did not have the jurisdiction to entertain the revision. For this, reference may be had to the judgment passed by this court reported in 2009 with bracket 3 PLGR 975, wherein it has been held that the Bihar Tenants Holding Maintenance of Records Act 1973 confers revision power only upon the collector of the district. Since the setting aside of the order passed by the Commissioner would revive another order which is without jurisdiction. This court is not inclined to exercise power to set aside the impugned order as contained in Annexure 12, passed by the Learned Commission, entertaining second revision. Accordingly, the orders Annexure 10 and 12 both are set aside. I have this option, no?
Yes.
Both are set aside. And further, it is sufficient to observe that much will depend upon the decision in title suit number 34 of 1973. अब आपके पास तो कोई कांटेक्ट नहीं है लिटिगेंट का, आपके पास है? नहीं। यहाँ से तो जाता ही है, कम्युनिकेशन जाता ही है। अब क्या पता कौन है?
सबका डेथ हो गया।
कंसर्न लॉयर का ना? सूट किसके पास फाइल हुआ था?
Additional
Hmm?
additional deputy commissioner. By virtue of wherein he had power.
The suit was filed before the
Additional deputy commissioner.
additional deputy commissioner. Since the suit has now revived, the additional deputy commissioner is directed to issue notice to the concerned parties.
She will direct even the deputy commissioner to ensure that. He may also be directed in addition to this. Even the commissioner will be supervising the.
73 का सूट कहाँ से कुछ करके निकालेंगे? बहुत मुश्किल है।
देखा जाए
Let us see. The suit be decided within a period of 6 months होगा.
like it has to go through the
Expedition.
preferably 6 months कर दिया.
The suit be decided expeditiously, preferably within a period of 6 months.
It's a
All contentions of the respective parties is limited.
एक उपाय है तो दोनों का कंटेंट चला न्यूज़पेपर में कल आ जाएगा पूरा सब लोग पता चलेगा केस
चलिए अब क्या बताएंगे.
my
इसका कुछ हो जाए तो
my
वही.
junior associate is saying that the writ petition is of his age.
Yes, the writ petition is of his
His
age.
age.
Correct.
Like
लेकिन इन लोगों को कुछ लीगल एड हम लोग को प्रोवाइड करना पड़ेगा, उसके बिना नहीं चलेगा.
कुछ तो एडिशनली इसमें कुछ या तो डालसा को लोकल डालसा को डायरेक्शन दे दिया जाए लुकिंग
नहीं,
डालसा एट
नहीं, एक
चाईबासा
second. Considering the fact that the parties are tribals, the authority shall ensure that proper legal aid is provided to them for conducting the case, and if so required, the Secretary of District Legal Services Authority be approved for the process. Chaibasa be approved for the process.
with regard to informing the parties. So something will be done through DALSA to make efforts in coordination with the deputy commissioner.
Let this order be communicated to the parties. The council for the parties have submitted that since the matter is very old and they are not in touch with the parties, let this order be communicated to the parties through the concerned minister. इस order को communicate कर दो. हो जाए?
From the daily list and reading for final disposal, item 1, WPC 3516 of 2003 along with item 2.
This is the preemption matter, Lordship. This is the preemption matter. The petitioner is the purchaser. and the respondent number 5 is the preemptor. Petitioner purchased the land. by
Just a
purchasing-
moment. Okay. You are the purchaser.
I am the purchaser and respondent number 5 is the preemptor. The petitioner purchased the land registered sale deed lordship. Thereafter lordship the respondent.
What is the date?
Date. 2010-1993.
2010-1993. You purchased.
Purchased. Thereafter lordship the preemption case was filed on 10/12/1997. And before the filing of the preemption case lordship, the petitioner executed and registered a sale deed in favor of his daughter, namely Ragini lordship.
When?
Ragini Kumari.
When?
When the gift deed was filed on 18/11/1997 before the district registrar and which was registered on 1/1/1998
For the transfer.
for the transfer.
It was registered on
It was registered on 1/1/1998.
18/11/97 date was registered on
1/1/1998. Due to long strike lordship,
striking register. What is the timeline for filing a petition for preemption?
what is the timeline of
Filing a petition for preemption.
preemption case lordship? 3 months lordship.
Pre-
There is no dispute relating to filing of preemption case lordship.
No, there is a dispute because it has been filed after how many years?
There is a dispute how many years?
Yes, purchased on in the year 1993.
The preemption case was filed on 10/12/1997.
1997.
Yes.
How many years after the purchase? 3 साल बाद 4 साल बाद.
Every was executed in 2010-1993.
Yes, and preemption case was filed when?
And preemption case was filed on 10/12/1997.
कितना दिन बाद?
बहुत दिन तो बात करेंगे.
हो सकता है.
नहीं हो सकता 3 months का.
तो आप तो ऐसा लग रहा है पहली बार सुन रहे हैं बात.
नहीं हम थोड़ा सा मिसअंडरस्टैंडिंग हो गया था. नहीं ठीक है जो 10/12/97 को हुआ.
ऑर्डर पढ़ाइए. तो भी आपका केस का है डिसमिस कर दिया. द रिविजन इज अलाउड. ये किस तरह का ऑर्डर है?
हाँ उनका जो प्रियम्टर का है उनका जो किसी इलाके या प्रियम्पशन केस फाइल किए वो अलाउड हुआ. उसके अगेंस्ट में 2 अपील फाइल हुआ. एक पिटिशनर और एक जो बेनिफिशियरी है रागिनी कुमारी वो फाइल किए. बोथ द केस वाज हार्ड एंड व्हिच वाज अलाउड.
ये इम्प्यूग्न ऑर्डर कौन सा? पेज 57.
यस पेज 57. appeal order of two orders, Lord. One the order of the DCLR and one the order of the learned member board of elections, Lord. Page 45, Lord. Instead it, Lord.
ये 57 किस तरह का ऑर्डर है? पढ़िए.
Board of elections का order.
हाँ.
Annexure 5.
हाँ.
10/5/2003, Lord.
हाँ.
That in this preemption division case, Ambika Dubey, son of late Martin Dubey, son of so and so.
नहीं, पेज 57 क्या है?
Page 57. Page 57 नहीं 56 है. Keeping in mind.
नहीं, पेज 57 भी है इसमें.
हाँ, page 57 में है. See rules 129, record of manual 1941. That this revision is allowed. The order that you pass will learn district along the side. Detailed orders part will be passed separately.
और ये डिटेल ऑर्डर कौन सा?
Detailed order is Annexure 5, page 45. Dear Proxy Court, may I read?
Yes.
Yes. This revision case, because the son of late so and so Jaipur district Palamu is the petitioner and preemptor. Uttim Raj Devi, wife of Rajendra Dubey, resident of village so and so Palamu, is opposite party number 1, and first transfer is Srimati Ragini Kumari, daughter of Sri Rajendra Dubey and resident of same village, is the opposite party number 2, and second transfer is Sri Ram, Sri Rameswar Ram, Sri Lalan Ram, all sons of late Nanak Ram, and resident of village so and so are the opposite party number 8. They are the vendor. The petitioner have filed the revision petition against the order dated 24/9/2002 passed by the Deputy Council Palamu in LC appeal number so whereby the appeal filed by the opposite party number 1 and 2 had been allowed in the order dated 1988 passed by Deputy Council and LC case number so had been set aside. The case in brief is that opposite party number 3, 4, 5 and 5 sold 15 dismiss of land of plot number so and so situated in village so and so by virtue of registered sale date 69/1987 for consideration amount to 30,000. The petitioner thereafter filed preemption application number 10/12/1997 before the LRDC Jharkhand who after hearing the applicant opposite party number 1 to allow the claim of the preemption. The opposite party number 1 filed separate appeal before the Deputy Council Palamu who after hearing the concerned party allowed the appeal by his command order dated 24/9/2002. The grievance of the petitioner is the gift deed of the disputed land executed and registered by the opposite party number 1 in favor of the opposite party number each policy fraudulent, sham and farji has been done to defeat the preemption case. The gift deed was registered 1/1/1998. Yet the CC Palamu failed to consider the gift deed came into effect after the claim of the petitioner for preemption was filed. The learned counsel for the petitioner, the opposite party number 1 and 2, and the state were heard at length since the opposite party number 3, 4, 5 did not appear despite the notice they could not be heard. I have reviewed the LC case number record as well as all the ruling file and papers on the record. The plea taken by the opposite party number 1 and 2 are that petitioner never said in the court of learned LRDC Sadar Jharkhand that gift was sham. The validity of gift deed can be decided by the civil court. Since the gift was executed 29/9/97, the registration was delayed due to a strike in the registry office. The gift deed, even though registered on 1/1/1990, would be effective from 29/1997. The opposite party number 1 and 2 also refuted the allegation of the petitioner that stamp paper used for registration of the gift it was intimidated. The gift was submitted for registration in the sub-registry land, but the gifting away of the total land, including the share of the opposite party number 1, showed that gift was not voluntary. Moreover, the valuation mentioned in the same deed and valuation mentioned in the gift vary very much, although the land is the same. In the same deed, the valuation is rupees 30,000, whereas the valuation mentioned in gift is only 10,000. Thus, by under valuing the government has denied its proper value, the gift deed therefore has been insufficiently stamped. The learned counsel for the petition submitted that at that time of the argument, the plea of the gift deed being same in further transaction had been taken by him in the court of the related alert which is other Jharkhand. He also pointed out the differences in valuation of the sale deed in the sale deed and gift. The further submitted gift deed was not a gift deed because the recital of the sale deed speaks of the repayment of the money invested by the opposite party number 2 in the transaction of office on 18/11/1992. This is prior to filing the preemption claim on 10/12/1997. The letter DP, the paying on behalf of the state, submitted the registration of the gift was did by the law of disbandment because the preemption case had been filed earlier to the date of registration. The gift deed should have been registered prior to filing of the preemption petition. He said the ruling filed by the opposite party number 1 and 2 regarding the gift deed are not applicable in the present case. He said that RN Deva case as contained AR and so would be applicable to this case. It was further argued that the special GP that the gift must be necessary.
You just come to page number 8.
Page number 8.
In the instant case.
In the instant case, date of recognition of gift deed is 29/97, but date of registration is 1/1/1998. It was presented for registration on 18/11/1998 when the preemption application filed. 10/12/1997, the aforementioned ruling would therefore applicable. The question of date of operation of the gift deed, but the said ruling has also laid on important condition that if the gift deed must fulfill, it was not challenged as the same and further. In the same or further in the present, it will always be the case of the petitioner the gift deed is same and further. This has been talked about to defeat the purpose of the petition regarding the preemption. The close examination of the concerned gift deed reveals in the recital the opposite party number 2 had invested their own money to a certain extent when the purchase of land was being made from the opposite party number 3 for this to return this money also from the love and protection of the gift deed was excluded. The question of consideration therefore comes in where a gift deed should not be based on the consideration. The execution of the gift deed does not seem to be voluntary either because the entire land is recorded in the evidence deed has been gifted away. Even the stand may be taken that there was no bar for opposite party number to gift her some portion of the purchased land. Therefore, the transfer is voluntary. The recital in the gift deed about the repayment of the funds in respect for the purpose of said land goes against the very nature of gift as defined in the transfer of the property. Once the question of repayment of the money invested comes in, it becomes the tantamount to consideration. No gift deed can be called a gift deed if the question of consideration is apparent from its recital. In further construction of this argument, it becomes evident that so-called gift deed was drawn up to defeat the provision of the land CBN because the opposite party number 1 was very aware that the sea was not adjoining area to the disputed land. The so-called gift deed was same and further can at best be given the status of the second transfer through sale. In this situation, the ruling quoted by opposite party number 1 and 2 will not be applicable. Rather, the ruling filed by the petitioner as contained in CWJC number 7 to Ram State of Bihar other would be applicable. In this case, it has been held by the Honorable Patna High Court by principle of this matter is very much applicable in such cases. If the preemptor makes application by transferring the same land to anybody else in dependency of the proceeding. The procedure for the subsequent transfer cannot be
क्या है
permitted.
इसमें registration तो हुआ है after the filing of the preemption.
No. The preemption case was filed 10/12/1997 lordship.
It was
And-
registered on 1/1/1998.
Bid was filed on 18/11/1997.
आपने किया होगा जो भी कुछ registration तो नहीं हुआ ना.
Registration नहीं हुआ 1/1 but lordship
You
according
see it from the date of registration.
lordship mechanism section 47 of the Indian Registration Act. A registered document would be operate from date of its execution lordship. Mechanism section 47 lordship. And similar matter lordship he appeared before the Honorable Division Bench and same plea was taken. And that let me at that case lordship I am opposing the parent. I was the private respondent lordship. Mechanically the judgment passed with the Honorable Division Bench lordship. राजीव रंजन सर थे उस केस में हम उसमें अपोज कर रहे थे कि नहीं इसमें एक्सक्लूड नहीं होगा सेम मैटर है सेम मैटर की कंप्लीट करने की Para available notes. जिस दिन से मेरा एजुकेशन होगा उस दिन से सैलरी मेरा ऑपरेट माना जाएगा अकॉर्डिंग टू सेक्शन 47 ऑफ द इंडियन रजिस्ट्रेशन एक्ट. Yes, before answering the aforesaid issue, provision of section 16 of the Act of 90 is required to be read which I follow. Restriction of future equation transfer. No person shall, after commencement of this act, either by himself or through any other person requires to purchase by the transfer, exchange, lease, mortgage, agreement or settlement any land together with the land if any already held by him exceeds in the aggregate the ceiling area. The explanation for the purpose of this section: transfer does not include the inheritance, bequest or gift. After the commencement of this act, no document in the corporation any transaction for acquisition or condition of the land by transfer, exchange, lease, mortgage, agreement or settlement shall be registered. I am escaping lordship. Now, lordship, may I say second page or page 285 also.
No, let us see. This is no, we are just talking about 16.3.
16.3
16.3 से हम लोग को मतलब है ना, preemption 16.3 से guided होता है.
आप lordship में कहें
16.3 से ही चलेगा ना.
चलेगा. हम 16 का 1 देखा जाए. 16 का 1 का explanation.
तो quoted ही है.
हाँ, for the purpose of this section, transfer does not include the inheritance, bequest or gift. Now, lordship, may I see section 47 of the Indian Registration Act.
आप section 3 में आइए ना. Section 3.
No right shall be transferred.
Subsection 3. When any transfer of land is
When any
made.
transfer of land made after commencement of this act to any person other than co-sharer or regent of the adjoining land, any co-sharer of the transferor or any regent holding land adjoining the land transferred shall be entitled within 3 months of the date of registration of the document of the transfer to make an application before the collector in the prescribed manner for the transfer of land to him on the term and condition contained in the same.
आगे बढ़िए.
Provided that no such application shall be
It
entertained.
is relatable to the date of registration.
Date of
Registration. Section 16.3 is relatable to date of registration. क्योंकि आपका भी तो deed 97 में 3 साल पहले का है. 93 का deed आप 97 में जाके registration कराएं. आप अपना देखिए.
deed was executed.
नहीं, आप अपना deed देखिए.
हाँ, मेरा तो 93 का है.
93 का registration कब का है?
रजिस्ट्रेशन मेरा ठीक है 93 का है.
आपका परचेज है 93 का, रजिस्ट्रेशन आपका 97 का है.
हाँ, रजिस्ट्रेशन 97 का है.
हाँ.
69/1997 परचेज है 20/10
तो रजिस्ट्रेशन डेट ऑफ रजिस्ट्रेशन से प्रीएम्पशन का एप्लीकेशन का डेट काउंट होता है.
हाँ, वो तो उसमें हम डिस्प्यूट नहीं कर रहे हैं. मेरा डिस्प्यूट है कि अकॉर्डिंग टू एक्सप्लेनेशन लॉर्डशिप ऑफ द 1968 लॉर्डशिप गिफ्ट नोट
गिफ्ट डीड का डेट क्या है?
गिफ्ट डीड का डेट है जो गिफ्ट डीड वाज फाइल्ड ऑन 18/11/1997.
18. आपका परचेज कब रजिस्ट्री हुआ है?
मेरा तो परचेज हुआ है 16/9/1997. रजिस्टर्ड हुआ है 16/9/1997.
16/9/1997. 3 महीना कब एक्सपायर हुआ?
69 अभी फाइल किए हैं
15/12.
ये फाइल किए 10/12/97.
ठीक है, 15/12/1997 को 3 मंथ्स एक्सपायर किया.
हाँ,
ये फाइल कर दिए 10/12/97 को विद इन टाइम. करेक्ट. अच्छा, गिफ्ट डीड इज प्रायर टू एक्सपायरी ऑफ 3 months. Correct?
The gift deed was presented prior to filing of the preemption case.
Okay, it was presented prior to, because you want to give that date, no?
हाँ,
Gift
gift deed
deed
was
is
presented on 18/11/1997
18/11/1997,
and gift deed was registered on 1/1/1999.
1/1/1998. ये जजमेंट में क्या बता रहे हैं?
बोले कि आर एडजस्टमेंट
So the claim of this preemption is defeated by virtue of the gift.
What mechanism is case 285.
If the section will not include transfer by gift, then under such circumstances, even if the property is transferred by gift, then how role of section 16.3 is excluded?
Will not apply in the matter of gift mechanism.
If in the matter of gift it will not apply, then under such circumstances, the deed, your deed, can be set aside.
Cannot be set aside.
Why?
Cannot be set aside.
The transfer will not include gift, no?
Lordship mechanism is the definition of
You see the definition once again.
definition mechanism.
Section 16. For the purpose of this section, transfer does not include inheritance, bequest or gift.
Gift.
Right?
Yes.
So if you are gifting it, then that is not transfer.
That is another matter, Lordship.
No. We are looking at the section. No, you are relying on this. That for this particular section, gift is not a transfer.
Gift is
Therefore, gift by you to your daughter is also not a transfer.
for the purpose of preemption, Lordship, this explanation has been made. So far as the gift is concerned, Lordship, if anybody is aggrieved by the gift, file a suit before the competent court of civil jurisdiction.
You forget about it. They did not have the jurisdiction to decide whether the gift is
Gift
valid
is valid or not.
That's fair enough. But the point is that whether it will be governed by this pendants or not. That is the point.
Then
If the
Lordship,
gift deed itself is not a transfer, then under such circumstances, how the right of preemption is coming into is curtailed?
I am the purchaser, he is the preemptor.
He is the
He is
preemptor.
the preemptor, he is claiming the land.
He is claiming,
I am the purchaser.
and you say by virtue of gift it was already transferred.
Already transferred.
But this section does not include transfer by gift.
For the purpose of preemption,
कहाँ लिखा? For the purpose of this section.
mechanism judgment passed by the Honorable Division Bench, Lordship. I am reading entire judgment, Lordship.
इसमें the gift was involved.
Yes.
Where is the fact?
Yes. Para 3, Lordship, I am reading facts of this case, Lordship. The brief facts of this case is need to be enumerated here in red agenda. The petitioner before the writ court, namely Radhika. Radhika is the purchaser of the property being plot number so and so and khata number itna so and so. Village so and so PS district Palamu from the respondent number 6 by virtue of registered city. The Radhika Devi is also purchaser. Herein also I am purchaser, he is also purchaser. That special case, Radhika Devi. The respondent number 5 claiming herself to be adjoining area of the said cultivated land filed an application under section 16(3) of the Act of 1963 before the land become deputy collector Palamu claiming her right of preemption which was registered as LC case number so and so. The writ petitioner filed her response to the said application for preemption filed by the respondent before the original authoritative taking point that property in the question is the homestead land. Further that the portion of the property is gifted to her daughter by virtue of registered deed dated 38/8/1991. According to writ petitioner, the formalities in the connection with the deed, including the handing over the possession of the property to the daughter, took place prior to filing of the application under section 16(3) of the Act, but was registered on 38/1991. And that is after filing of the application for preemption by the respondent. इसमें तो है कि after filing है, मेरा है before filing. The said application was rejected by the land reform deputy collector on 2/1/1992 passed in LC case number so against which the appeal was filed by before the deputy commissioner Palamu registered as a land civil case number so which was also dismissed. Against the appellate order, the respondent number filed a revision case before the member board of revenue Bihar and Patna which was registered as revision case number so dated 26/1996. The order passed by the lower authority was quashed and matter was remanded to fresh consideration by recording and finding that gift deed involved in this case will be governed by the doctrine of least pendants. Accordingly, said gift deed could not thought preemption. under the member board of revenue also recorded there is no finding in connection with the fact that whether the preemptor was adjoining right or not. An issue was raised on behalf of the writ petitioner. The order dated 26/12/1996 did not prevent the authority before entering into dispute as to whether the gift deed would be governed by doctrine of respondents or not, and it was open to them to contend that the provision of section 63 would not apply to the gift deed at all. This is the submission of the petitioner. So far as the point
Where
regarding
is the finding?
findings of page 285, Lordship, I have marked yellow. Therefore, the word transfer is a paramount consideration as you appear from the explanation as contained in section 61. The transfer does not include the inheritance, bequest or gift, meaning thereby if the transfer has been made by way of inheritance, bequest or gift, the provision of section will not be applicable. As would appear from the facts of this case that a part of the land in question, that is to the extent of 11.11 acre, has been gifted by the title holder, namely Srimati Radhika Devi, on 29/7/1991 in favor of her daughter, namely Srimati Pramila, meaning the gift was executed on 29/7/1991, and the registration of the aforesaid document dated 30/8/1991. The application under section 1960 was filed by the respondent filed 21/8/1991, basis upon which it has been claimed that said application has been made prior to date of the registration and after date of execution of the gift, that is 29/7/1991. Therefore, as per the principal list pendant, the aforesaid registration date 38/8/19 has got no value in the eye of law. This court has examined the aforesaid issue by taking into consideration the effect of the execution of the gift deed, the deed of registration, in which the provision of section 47 of the Registration Act has been considered as follows. The time from which the registered document operates. The registered document shall operate from the time from which it would have commenced to operate if no registration thereof had been acquired or made, not from the time of registration. Section 47 of the Registration Act therefore provides that a registered document shall operate, important law, to operate from the time it would have commenced to operate if no registration thereof had been required or made, not from the time of its registration. The scope of Section 47 of the Registration Act was the subject matter of the consideration before the Honorable Appeals Court in so and so. And the Honorable Appeals Court reiterated the position of law that sale would become complete only the registration of the sale did take place, not before. Thus, by virtue of Section 47 of the Registration Act, it would relate back to the date of the execution. However, by registration of the document transferring the immovable property, the transfer would become complete, though it may affect the date of interior to the date of registration. Reference in regard may also be made to the judgment rendered by Apex in case
So
of
transfer is not complete unless it is registered.
registered.
Once it is registered, it will relate back to the previous date.
Yes, from the
But-
date of execution.
From the date of execution.
From the date of
But unless it is registered,
Yes.
the transfer is not complete.
Transfer is not complete. The reference in this regard may also be made to the judgment rendered by the Honorable Apex Court in case of principal security so and so to further section 10 SCC 424 when it has been held that document registered on a subsequent date operate from the date of execution, not from the date of registration.
But the transfer is not complete
Transfer is not complete.
before registration.
Yes, yes. In the another judgment rendered in the case of so and so, the Honorable Apex Court in paragraph 3 has in view of the provision of section 47 of the Registration Act, it will illustrate that the document on subsequent registration will take effect from the date when it was executed, not from the date of its registration. The applicability of the provision of section 16 of the Act 1961 in this case would be there if gift deed dated 29/7/1991 will be declared to be sham and forgery, but said gift deed having been executed 29/7/1991, which is prior to application filed under section 63 of the Act, that is 21/8/1991. In this case also the
अब बीच बीच में मत
अच्छा,
पढ़िए.
ठीक. The said gift deed cannot be said to be sham and forgery because law is well settled that in absence of categorically finding or evidence that gift deed executed on the date of preemption cannot be held to be forgery or sham document if the private respondent have failed to establish the above fact no preemption can go into the said transaction merely because they coincided. In the case of so and so 1995 PSGR, a division bench Patna High Court has held that deed executed before the filing of the preemption application by the registered during the pendency of the application is excluded from the purview of the preemption. So such transaction can be hit by the provision of section 63 of the Act only if there is an allegation of sham and further transaction. The authority finds the allegation true. In so and so cases, it has been clear that right of preemption is a very weak right, and preemption is required to follow each and every mandate of law. Failure of including the transference is an application for preemption must be cited to its maintainability. As such, an application has to be dismissed at the initial stage. In so and so court, it are excluded for the purview of section 16(3) of it. Involvency to exclude the only the purpose of the section 16(3). Herein, admittedly, the application under the provision of section 63 of the Act 1960 was filed on 21/8/1991 for the property which had been gifted by a gift on 29/7/1991. However, the same was registered on 38/1998. But as per the provision of section 47 of the Registration Act, the date of registration will not have paramount importance. Rather, the date of registration of document will go back to the date of the execution of the sale. The date of registration is 38/1991 of the execution of the sale is 29/7/1991. Means the applying the provision of section 47 of the Registration Act, the registration of gift will go back the date its execution 29/7/1991. Therefore, the application under section 16(3) of the Act 1960 having been filed on 21/8/1991 of a gifted landed property in view of the provision of section 63, one of the gifted landed property would not come under the fold of the definition transfer. As such, the provision of section 63 will not be applicable in that view of the matter. The principal lease pending as has been concluded by the revenue authority which has been approved by the next single day cannot be said to be any legal force. The further fact which is admitted the preemption application filed under section 16(3) of the Act is with respect to the area of 0.21 acres as would appear from the original application has been appended as a refer to the memo of appeal. But the position of law here is clear that preemption application is filed. Same is to be filed with respect to the entire land. Reference in regard be made to the judgment rendered by so and so reported in the AIR so and so meaning held that person claiming preemption must claim the right of the reconvenience with respect to
That's right, heard you. और बताइए इस पर क्या बोलना है?
I am not disputing the set finding of the division bench. In this case, my lord, in that case, as it is said just now, the transferring was made party, right from very beginning. In that case, she was not made party, the Dhoni was not made party. Here in this case, the Dhoni, the moment LC case was filed and 20 case surfaced that the guilt was registered.
That is not the reason for deciding that case, that Dhoni was not a party.
नहीं उसमें है
कहाँ ये रीजन तो है ही नहीं ना ना
उसमें नहीं है।
नहीं यहाँ मेरा जो कहना है यहाँ पर है कि तो फर्स्ट कोर्ट में ये इशू को लिया गया कि ये सेंट्रिक फॉर सामने फर्जी ट्रांजैक्शन एंड दैट वाज कंसीडर्ड बाय द कोर्ट्स
फर्स्ट कोर्ट में कहाँ लिया गया है कि शैम एंड फर्जी ट्रांजैक्शन उतना दिखा दीजिए उतना में एक डिस्टिंग्विशेबल हो जाए बात खत्म है बिकॉज द कोर्ट सेज दैट इफ इट इज हेल्ड दैट इट इज शैम एंड फर्जी देन द मैटर एंड्स
हाँ
then the case will be clearly distinguishable.
हाँ
बताइए कहाँ है sham and फर्जी ओरिजिनल कोर्ट का रिकॉर्ड कहाँ पर है Annexure 3 LC केस नंबर 6 of 1978-19 बताइए Annexure 6 का कहाँ है
ये इसमें नहीं है।
आता याद है सर दूसरी कमर इसमें सुधार से प्रभावित होगा आता है मतलब सिक्योरिटी क्या है तो मालूम है सिक्योरिटी तत्पश्चात आवेदक के अनुरोध पर द्वितीय क्रेता फर्स्ट में लिखा है सोनसो रागिनी कुमारी सुशील राजेंद्र दुबे को प्रतिवादी बनाकर सूचना दी गई। उनका कथन है कि उनको बख्शीश आवेदन आवेदक के द्वारा करने की पूर्व हो गई है तथा उन पर विधि लागू नहीं होता है। सभी पक्षों को सुना और सुनने के बाद प्रतिवादी संख्या कभी भी इस तरह स्वीकार नहीं किया है कि आवेदक बुनियादी भूमि जो इतना समीप की रही नहीं है। आवेदक पूरा विधि आवेदन में दायर किया गया कि आवेदक एडवर्टाइजमेंट रहित होने के कर स्वीकार करते हैं। प्रतिवादी संख्या इतना रेलवे उत्तर अपनी उम्मीदवार ने कहा है कि उन्होंने उत्तर इतना बख्शीश रागिनी कुमारी से द्वितीय क्रेता का कथन है कि उन पर धारा 66 लागू नहीं होगा क्योंकि आवेदक के दायर करने के पूर्व हो गया। बख्शीशनामा देखने से स्पष्ट होता है कि यह बख्शीशनामा निबंधन कराने के समय तो उसी दिन निबंधन कराने के समय बख्शीश दस्तावेज करने से स्वीकृति प्राप्त हुआ। अगर विधिक रूप से यह दस्तावेज एक निर्धारित स्वीकृति
कोल्यूसिव का तो फाइंडिंग नहीं
हमारा सारा
ना फाइंडिंग है ना प्लीडिंग है ना कुछ है।
प्लीडिंग है, प्लीडिंग तो लाइन है
नहीं है वो तो आप ना बताइएगा क्योंकि इम्प्यूग्ड ऑर्डर में तो दे दिए हैं कि कोल्यूसिव है। कहाँ है कोल्यूसिव का फाइंडिंग?
नीचे तो
कहीं नहीं है। आपका कोई केस भी नहीं है कोल्यूसिव का।
मेंबर बोर्ड में तो सब ठीक हुआ।
मेंबर बोर्ड में कोल्यूसिव का केस बनेगा पहली बार।
नहीं
शुरू से कहाँ है बताइए ना, कहाँ है कोल्यूसिव का केस? पढ़िए, आप तो पढ़ ही रहे हैं ना जज।
कर देते हैं खाली जो ऑर्डर तक लिखते हैं। अगर आप कोई डॉक्यूमेंट लाए तो
ऑर्डर में भी कहाँ लिखे
हम नहीं कल ही कंक्लूड हो जाएगा उसमें क्या।
The learned counsel for the appellant has concluded his argument and has submitted that the present case is fully covered by the judgment passed in LPA number 208 of 2018, decided on 4/11/2020, reported in 2021 within bracket 1 JBCJ 278 within bracket High Court. The counsel for the respondent prays for adjournment. उस वक्त बहुत सारा रेट हम डिसाइड किए थे। मेरा डिसाइड क्या हुआ रेट है?
नहीं आपकी जो है आपकी
मेरा है ना, हमको एक केस का नंबर से याद आ रहा है। इसका ऑर्डर
उसमें हम लोग जीत गए थे उसके अगेंस्ट
WPC 6303 of 2000
को याद है
WPC 6303 of 2003
जी
ठीक है।
जी
Pose for the argument of the learned counsel for the respondent. Tomorrow, first case 2:15 बजे। ऑलरेडी 4 बजे केस फिक्स था ना।
यस सर। From the daily list, this case at 10:30 AM. Under final disposal, item 2, FA 4 of 2014, along with item 3 to 5.
इसका एग्जीक्यूशन
There.
Yes, madam.
The compensation has
To
been
इसमें
decided.
लाए। Yes, please.
The compensation has been decided based on the judgment passed with respect to some other error, and 600 because the Honorable High Court had taken the coordinate bench of coordinate the Honorable High Court had taken 600 rupees per decision. Considering that law, my case has been decided. Now, Exhibit 2 is related with the village visit.
Did you file anything to show that what was the mode of computation?
That yes, we have brought on record.
What is it? It is based on what?
It was based on the officers of the state, they had.
Is it based on any say deed?
Well, the first thing first, that I had relied on a judgment on the previous occasion as well.
I don't.
Whosoever comes before the honorable court that the compensation is good or not adequate, the onus lies upon that person.
That's
Milord, that judgment is burden of proof,
Yes.
2013-14,
2013,
volume 14,
14 SSC,
page 50,
page 50,
para 9 is the relevant.
para 9. Burden of proof.
Burden of.
Okay.
Now it is upon the claimant, they are considered to have stepped into the foot of the plaintiffs, and entire onus rely on are on them to prove that the compensation is not sufficient. Now, my lord, only 2 paragraphs of the impute order I want to read first, if I am permitted to do so. What they have discharged as the burden upon them.
Okay.
Just the 2 paragraphs.
Yes. Para number.
Para 14 and 15. 15 I will give you.
Para 50.
Yes.
Yes.
It is in the running page 2.
Yes, yes, yes.
Though it is claimed in all the petitions that the rate of acquired land is rupees 10,000 per decimal, but during oral evidence, only one claimant, that is claimant of reference number 1 of 1996, has stated that the value of the acquired land is rupees 10,000 per decimal. Claimant of remaining cases have admitted in their evidence that the acquired land is having value of 3,000 rupees 3,500 per decimal. In this way, there is no consistency in the oral evidence of the witnesses in respect to the rate of the acquired land. There is no evidence in respect to the enhancement of compensation in respect of trees, though claimant has sought for the higher compensation for the trees, but no basis for the same has been brought on record by them, nor legal evidence has been adduced in this regard. In this view of the matter, claimants have not been able to substantiate their claim for higher compensation for trees as claimed. So, with respect to the land, whatever, there is no consistency with what they have deposed and their claim, what they had produced in the court below, they had filed. And even for the other compensation, they could not produce any document. So the onus was very much upon them and they have failed. Now coming to para 14, Miller.
Para 16.
Para 14, just the above that. Though in this case, no any sale deed has been brought into evidence by any of the parties to the prevailing market rate in the locality. But on the basis of Exhibit 1, I am of the opinion that rate fixed by OP in respect of village Laio was not adequate and in accordance with prevailing market rate. In that very case related to Exhibit 1, several sale deeds were produced by the claimants and all were considered by the Honorable Court. On the basis of evidence available, on that very record, flat rate has been fixed as rupees 600 per decimal. Exhibit A series are the notification. So, my lord, in that case, n number of sale deeds were produced by the claimants, and then the High Court, the Honorable High Court, came to a finding that 600 would be the flat rate. Now, my lord, this Laio village, based on which 600 has been placed, has been considered by the court below, that may kindly be seen from the map below. The map,
Not the Laio village.
yes, yes,
See?
ये 600 जो है,
Just a moment.
Exhibit A के ऊपर किया गया है.
Exhibit 2 is what?
Exhibit 2 is with respect to
Parij and
Daru
Daru Kasman.
Yes.
Exhibit 2. What
Yes.
was the rate in this?
In this, it was 727. Per decimal was 727, and 20% was deducted towards the development cost. That would come to your 581. In this particular case, 600 flat rate has been taken as per Exhibit 1 of Laio village, and no deduction towards development cost has been given. So their claim has been decided based on Exhibit 1 of some other village, for which a different notification was there. Exhibit 2 is with respect to the other villages which were acquired with the same notification. Now coming to the Exhibit B below, the map.
So far as Exhibit 2 is concerned,
Yes,
it is relating to adjoining villages.
that I have to show. Milord. For that I
Show
was
me, where is the map? Tell us.
It is in the 5B, Milord. Map is in 5B. Exhibit 2, if not mistaken, it's page number 54 of what ladyship is having. वो fold किया हुआ बड़ा सा. Now my lord will kindly come to my village 112 Pindra. Top में होगा 112.
112.
Yes.
Yes.
This is the map which has been filed along with the record. Now they are very faint. I am giving the color
नहीं नहीं
copy of
फेक नहीं है
it.
एकदम फर्स्ट क्लास.
You could have made from that only. This
There is
is
no
why
problem.
I have just-
आपको जो देना है दे दीजिए, कोई दिक्कत नहीं.
उसका
हाँ दे दीजिए, कोई बात नहीं. ये इसी से मैचिंग होगा ना, कोई अलग थोड़ी होगा.
फ्रंट कॉपी है इसका, हम क्लियर फोटो कलर फोटो दे रहे हैं. सेम चीज है.
112 is Pindra, madam. My village.
Okay. Pindra is in two
The
parts.
top.
Top में.
Pindra. Yes.
Below then, Daru Kaswar and Parej may kindly be seen. 117 and 108. 117 is Parej. 108 is Daru Kaswar. Just Parej के बीच में extreme है मिलोड या because
Arrange है.
Parej is 117.
Yes. दारू कसम.
Daru Kaswar is next to Parej.
That's right.
That is 108. इसके बीच में उलाना बारिसर जस्ट पिंडरा के नीचे एक दूसरा विलेज आता है 111 उलाना या उल्ला that was not
Yes.
yes
Ulaha.
Ulaha and
That was also acquired.
that was not
Simultaneously.
required with the same notification
In the same notification, which all land was acquired?
Pindra
Pindra,
Parej
Parej.
Kasma
Only 3.
as far as
No, you have to tell us.
I'll be clarifying that later.
Yes.
However, the exhibits that has been shown
No,
below,
exhibit 1 is relating to which village?
it is Laiyo village.
Where is
That is at 162. Right hand side में एकदम extreme पे होगा. नीचे में दारू कस्मर से और नीचे आइए उलाना बरिसम दारू कस्मर
Yes,
इचापड़ी
160.
लइयो
Like.
इचापड़ी के बाद लइयो.
Yes.
So we know this is not adjacent. This Pindra and Laiyo, these are not adjacent villages. That cannot be the same scale for which, even if the court has considered 600 at that point of time, it has different location, altogether different.
Which all villages were acquired by the same notification?
But I'll say that. Now coming to a judgment, I would like to go.
Yes, on the last occasion we were referring to those acquisition by the same. Which is that notification? Which all villages were acquired by the same notification?
It is at page number 3.
Para 3 of the judgment. You see, it is Govindapur, Indira, right? Rota is also there. This Pindra is also there. Tapping is also there. Tapping is entirely there. And Parej is adjoining to this tapping, and tapping is adjoining to Darukasma.
Yes.
Correct? Rota is there. Rota is also there. Rota is there. Then Barisam. Barisam is not there.
But the fact remains, if notification say if 13 villages are being acquired, my lord, or 14 villages, same rate cannot be given to all the villages.
I just want to know, apart from your submission, that it was there on us,
Yes.
right?
Yes.
What is there in your rate chart?
That has been illustrated, my lord.
What is there in your rate chart? Is it based on some sale deed? What is it based on? At least rate chart gives the mention of the sale deeds. Is it mentioned in the rate chart? Have you exhibited any sale deed? No.
Sale deed has not been illustrated.
So rate chart is gospel truth.
The state.
Let us see. Let us see what is your rate chart.
Yes.
Rate chart is based on what?
It is at internal page number 4 of the judgment, my lord. Para 6. Exhibit D. Class. Page 65 में लिखना है, the rates have already been approved by the competent authority for the land and trees under the acquisition as mentioned below. As
See, approval से नहीं होगा ना madam. Rate chart is always based on some sale deeds. Where is it?
You know, whatever was the fault on my part, if at all there was a fault on my part, they
See,
have.
you also have to show some basis. That there was some basis for fixation of rate.
You know, in the worst case scenario,
Yes.
suppose it could have been an ex parte order. In worst case scenario, I would not have participated.
That's
They would have participated. They are in the plaintiff. Even if I would not have been there, my lord, it was the plaintiff. They have to bring on record why this compensation is not adequate, why it is faulty, why it has been whatever the rate that has come upon.
While we are faced with a situation where the compensation has been fixed on no basis, I just want to see from the rate chart, at least from the rate chart, as to what is the compensation fixed. And this rate chart was exhibit. This was prepared when? When was it prepared?
The rate chart was prepared on date it has been mentioned 27/3/96.
96. Who has
Considering the
exhibited it?
acquisition,
Who has exhibited it? And when was it exhibited?
CCL
When was it exhibited?
was exhibited 27. Vice Punch Exhibit D. At page 80 it has been mentioned 22/5/2013.
So according to you, और ये जो जिसके बेसिस पे फिक्स किया एग्जिबिट 1 एंड एग्जिबिट 2, ये जरा जजमेंट दिखाइए एग्जिबिट 1 एंड 2.
Exhibit 1 is the judgment of Honorable High Court. By Justice Bhushan and Shabana. That is exhibit. उसने 600 कर दिया गया था मिनट कि
This
ये
was
वाला-
acquired on 1/3/1980
yes 1980
and इस केस का एक्विजिशन का डेट क्या है? 1980 में ही है ना?
81 notification under section 4 was 13/1/1981 and the possession of the land has been taken in the year 96 में
Hardar. Where is Hardar?
One of the recent judgments of Honorable Supreme Court says that even in the same village, two land situated at two different places would not call for the same compensation. So यहाँ पे तो one village separated by so many villages in between, and Layo comes after 6 or 7 villages from Pindra, and that
You
has
see,
been
there is acquisition of Pindra, then you have acquisition of this Taping, and then this Parija is adjoining to Taping, and this Durgasmar is also adjoining to Parij. Yes. Yes. So Pindra, these 4 villages are all adjoining to each other.
And my compensation has been decided as per Exhibit 1 below, and the Honorable Supreme Court, this judgment may kindly be seen.
Yes.
Civil Appeal Number 2732 of 22.
Para number?
Para 13, same village, different location, different compensation. At page number 22, para 13. Now, so far as the compensation determined differently for different land acquired with respect to the same village, Bioya ranging from rupees 1,50,000 per hectare to rupees 2 lakh per hectare is concerned, different market value compensation can be determined for different lands located differently in the same village or locality. In the case of Trilochan Singh Sutra, it is observed and held that it is common knowledge that all the lands in the same village may not possess the same quality and command the common market price. So,
But in a case where there is no sale deed with respect to the locality at all, what is the parameter and how the compensation is to be determined? If there is no sale deed, it's a case where there is no sale deed. Do you want to say that it is zero value?
no, they have come to a
That's
value.
it. So
as
I
per
want to
the
know. So
official. Every land has got a land value valuated by the state. Even wherever we are residing, the state.
circle rate cannot be a basis for fixation of value, because circle rate is not the market value. Circle rate is not the market value. The market value has to be determined on the basis of the parameters of market value.
Again, that if they say this is the circle value is not the market value, my lord, every time the onus lies upon the plaintiff, my lord. They should have come up with the same.
Yes, it is a case where there is no sale deed executed, so far no sale deed exhibited with respect to the property of the village.
Yes.
Then, under such circumstances, whatever you fix has to be taken as a gospel truth. This is the question. And was your calculation is referring to any sale deed?
It is not right.
It is not referring to any sale deed. So, what is the basis of your rate chart? On the one hand, you have just exhibited your rate chart, and on the pedestal of the rate chart, it is not based on any sale deed. Then, something has to be fixed. I can understand that your rate chart is based on some sale deed, although the judgment says that even that sale deed is required to be exhibited. Even if the rate chart is based on some sale deed, that sale deed is also required to be exhibited. And a person who is exhibiting this rate chart, after a long gap, what kind of cross-examination can come so far as that person is concerned? So some parameter has to be there. You cannot say that your rate chart may not be based on any sale deed, still they have the onus to prove and bring the sale deed on record. Whatever they had, they have brought on record. The point is, when before the court there is no sale deed, the rate chart itself is not based on any sale deed, then under such circumstances, the court has to do something about it.
We'll address this issue, my lord, and try to find out judgments on this
You
issue
try and
as well.
find out judgments.
On this issue as well, where
Yes.
there is no sale deed.
There is a division bench judgment of our court passed by Honorable Justice S.B. Sinha, right? Where it has said that the rate chart is not an evidence. The rate chart by itself is not an evidence. Okay. Kal. The arguments has remained inconclusive. Post this case for further argument tomorrow. वो पहला वाला केस में थोड़ा टाइम लगेगा, half an hour, and then the learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2013 bracket close 14 SCC 50 para 9 to submit that the burden of proof was on the claimant. Onus or burden? Onus was on the claimant to prove that the compensation was not sufficient. Sir, खोजिए.
Burden of proving, what it has been mentioned. Burden of proving that the amount of compensation determined in the award under section 12 was inadequate.
Burden of proof. सर वो खोजिए, वो एक जजमेंट है. अभी रिसेंटली एक केस में हम उसको रिलाई भी किए, लेकिन हमको बोला. और एक जजमेंट हम भी डिसाइड किया है जिसमें लिखे हैं कि रेट चार्ट, if it is based on circle rate cannot be a parameter for determining the compensation. It has to be fixed on the basis of market value.